Hello, my name's Moira McConnell. I'm a professor of law at Dalhousie University, Schulich School of Law, and I'm also an associate director of the Marine and Environmental Law Institute. Today I'm going to give you a brief presentation on a topic very dear to my heart, the Maritime Labour Convention of 2006, which is an international labour convention in the maritime sector. So I'll be talking to you about that, give a brief overview and a history of it. But before I do that, I would like to take a few minutes to tell you a bit about myself and my connection with the Marine Environmental Law Program and Institute. I think, in fact, I've probably been involved with Marine Environmental Law Program in one way or another ever since I got interested in law and came to law school at then Dalhousie Law School in 1981. I actually had no maritime connections at all when I came here, and I, on reflection, don't really remember why I went into maritime, but I had the great fortune of being taught by many people who later became colleagues and are, of course, also associates and fellows of the Institute. Now, for example, I learned about admiralty law, collision and salvage from Edgar Gold, Wiley Spicer, and Donald Ferran taught me law of the sea. My colleague now, Phil Saunders, also was starting law school in 1981, so we ended up in many of the same classes together. And during that time, my colleague David van der Zwag was at the law school, and similarly also Norman Ledelick, Ted McDormand, all very familiar names to us, were in the law school or around the law school at that time. Later, I went to Australia for postgraduate work for my PhD, which was in the area of shipping and international law and development, and met someone else who's a very close colleague and has a good relationship with our institute, Professor Don Rothwell from Canberra, University of Canberra. So it's been a long history. I came back to teach at Dalhousie in 1989 and was replacing Edgar Gold in the Law of the Sea course, as if one could replace Edgar in Law of the Sea while he was on sabbatical. And I've remained teaching usually one or more courses in the Marine Environmental Law program, sometimes business and environment, sometimes Law of the Sea, sometimes maritime law, for now 25 years, more than 25 years. I've also been the director of the Institute when it was created in 2003, and I am now taking a turn as the associate director. So a long history, and as I said, my life and my research has really tied me very closely to this institute and to my colleagues working in it. Now, I want to move now to talk about the Maritime Labour Convention. So having told you about the Maritime Convention, you might have wondered how the topic of labour came up. It really came through my secondment for a couple of years to World Maritime University, where I was also working on IMO conventions, ballast water and other conventions in the marine environmental law area. And I met the director, one of the directors of the International Labour Office, who was involved in a process in the organization starting in around 2002 to bring in a really interesting new maritime labor convention. In 2003, I began working with the ILO, providing advice with other people on both the drafting, and was involved in the consultations for the 5 years leading up to its adoption in 2006. And since then have really had a tremendously interesting and privileged time being involved in assisting countries with implementation, looking at some of the difficulties coming out of implementing this convention and some of the very exciting aspects of it. Most recently, last term, I was on leave and was able to work with the International Labour Organization, reviewing the very first reports from countries on their implementation of this convention, which as we'll discuss in a minute, is over 100 pages in length and is a rather complex convention. So very interesting time, and my short overview, as you can imagine, is a little difficult for me to be brief, but if you have any questions, please do feel free to email me or contact me, and I'd be very happy to answer further questions. So just moving on now, I'm going through the PowerPoint here. I'm assuming that many of you might be interested in environmental issues, but may not, or marine, but may not know actually much about maritime law and the system. So just briefly, to give you a quick note on the regulatory framework, and my topic is really looking at humans at sea and the forgotten humans at sea. Generally, we can say that the 1982 United Nations Convention of the Law of the Sea, along with other state instruments, international instruments, really sets the constitution for the ocean, the framework for regulation of this body, international body of water in particular. Relevant to operation of ships or maritime sector, under the Law of the Sea Convention, the state with the primary responsibility is an entity called the flag state. So I would see the state as having two and certainly 3 or 4 different faces. One of them is the flag state, in which the state has responsibility for regulating activities of ships flying its flag. That is, ships registered in a particular state. There's surprisingly then, although the Law of the Sea Convention sets out many, many areas that you will be hearing about from colleagues, maritime boundaries, resources, fishing, so on. In fact, there's very little about the humans. In fact, basically 1 or 2 articles, particularly Article 94, which assigns the flag state responsibility for labor and social matters on board ship. And that's basically it. There's a few jurisdictional clauses, but the flag state has that central role. The Law of the Sea Convention also, though, reinforced the role of, and now the very strong role of what we call port states. That is, countries that have ports and have ships of other countries, flying flags of other countries coming into their ports, and may take some actions, inspect those ships and so on, in particular for compliance with other international instruments. A related role is coastal state role, which might be some ability to regulate ships operating within certain bands of the coastline, water on the coastline. But basically those are 2 faces of the state. A state could be a flag state and a port state and a coastal state, such as Canada. In addition, and this is a new thing introduced under the Maritime Labour Convention, we're going to see the emergence of what I will call labor supplying responsibilities for matters such as social security and regulation of recruitment and placement as an element of this, the face of the state in maritime affairs. But that latter role, labor supplying, is not at all addressed in the Law of the Sea Convention. But we do have these different roles that the state can play. So that's the very briefly the sort of wider legal framework. Now, so what's the problem? What is the issue we're looking at here? Shipping, and particularly maritime trade, is one of the most international, in fact it's the earliest of the international industries. It's arguably the most globalized workforce, and it's almost what I would say inherently a globalized industry from the very beginning. And we've got, looking at it from a structural or a globalization perspective, we can think about the ship as sort of a workplace, a plant, a living space. The people working on board live on these ships, traveling around the world. Often these ships are not flagged in countries that is not the ordinary residence of the worker. Often the employer, the ship owner, is not from the state in which the ship is flagged. And the ship itself is continually moving. There are some, of course, domestic industries, but for the most part, we're thinking really about an international industry, and that's where the regulatory concerns most often arise. And in addition, ships are highly mobile. Like other kinds of corporate entities, they can change jurisdiction and, in fact, change regulatory control. At the same time, ships and the maritime sector is vital to the world economic system. Ships carry about 90% of the world goods, and in addition, of course, with growing recreational leisure industries, ships are also a primary source of income and employment. The other actor in this, a ship owner or operator, is also an employer, and this is also often a situation with increasingly complex corporate arrangements, often involving one or more jurisdictions, delegated and subcontracted authority. Often now ship owners may well use ship operators or ship management companies. And very often, and we've heard about this in the case, for example, of some of the more famous spills, environmental incidents, it can be quite difficult to identify a final responsible entity, particularly if they're not based in the flag state concerned or in the seafarers. There's several other actors that are part of this structural arrangements. One is a very increasingly important one in the last couple of decades, are the growth in companies, that is private commercial entities called private seafarers recruitment and placement services. They might be called other names, manning agencies, crewing agencies. It's a corporate service that essentially, as the name suggests, recruits and supplies seafarers, very often from developing economies, but not always, all over the world, often on vessels owned by different ship owners. These commercial entities are usually based, located in the state of residence of the seafarer and not in the flag state or the ship owner's state. Again, there's no hard and fast rule, but this is often a configuration. Then finally, we have in this sector seafarers. Seafarers can work on ships that operate internationally. They can be drawn from many different countries and many different arrangements relating to employment, differing employment agreements, and so on. So very complex workplace at the same time on a single ship. In addition, these workers, the seafarers, can change ships, employers, ship owners, frequently with every voyage sometimes, with different contracts, sometimes 4 months, 9 months, maybe longer. And they're sometimes described as a unique migrant workers, frequent jurisdictional change, but no real change to residence. So again, very complex issues from a regulatory perspective. Now I've realized I've rushed through very quickly, but I now want to move now into actually looking at the convention. These first comments are really to give a flavor of the complex international regulatory framework and the globalized nature of this industry. Moving now to what is the ILO? Well, it's the International Labour Organization, created 1919 following World War I with the Treaty of Versailles. It predates, in fact, the establishment of the United Nations, but in the 1940s it became the first of the United Nations specialized agency. And it's unique in the UN in that it is what's called tripartite. So unlike most United Nations or international organizations where the state, that is governments representing the state, are the parties and members, the ILO envisages the state as comprising 3 different groups: workers, employers, governments. And they all have a role in the International Labour Organization and in meetings and conferences in voting to adopt conventions and so on. The state remains, of course, the responsible entity for implementation, but these workers' employers do have an important role. And as you'll see when I talk a bit about the history of the Maritime Labour Convention, this is really a very significant element in, I think, its success and in its creation. Right, so moving to look at the ILO. Now, although most of you, I think, have heard of the IMO, and we often think of the IMO as really the agency dealing with maritime matters, in fact, the ILO has been working with the maritime sector for nearly 100 years. One of the very first legal instruments that it adopted was in 1920. It was the National Seamen's Codes recommendation, and even in 1920, there was foreseen this internationalization of the sector, that in fact there needed to be international minimum standards for all seafarers, no matter where they were from, no matter what ship they were on. In a way, that vision culminated at its 94th session in 2006, when the International Labour Conference adopted an important new legal instrument, the Maritime Labour Convention 2006. It's been described as historic, a way forward, and it's intended to establish an ILO goal, which is called decent work, meaning decent working and living conditions, and at the same time fair cooperation and a way to achieve fair globalization. So this is the convention we're going to look at. Where did it come from? I mentioned the importance of tripartism a few minutes ago. In 2001, it really came from this group, the representatives of ship owners and seafarers on an ILO body called the Joint Maritime Commission, came together. So it really came from the employers and workers' representatives. They proposed a whole new approach and what they called preferred solutions, and sometimes called the Geneva Accord, for maritime labor standards to better provide what they saw as the necessary effective protection for seafarers' right to decent work, and at the same time an economic goal, level playing field for governments and ship owners to deliver protection and accommodate diversity of practice. Well, now why? Why did ship owners want international standards? What was the problem? Well, up until 2001, there had been over 40 conventions and related recommendations, guidance from adopted, so well over 60, almost 70 instruments adopted by the ILO at that time. But they really were not very effectively implemented. There was a patchwork of countries ratifying them, sometimes only a few countries ratified, sometimes there was more. It was not a particularly strong system in terms of enforcement at the shipboard level, although the ILO itself has a process called Committee of Experts where they review legal implementation of countries that have ratified. It's relatively unknown, I think, in the maritime world, and certainly somewhat distanced from the ship owners and seafarers that are to be affected by the standards. So some of the reasons for change, there's a long list here, and I realize the print's perhaps a bit small, but through the decade, particularly in the 90s, there was late 90s, early 2000, there was a very influential report, the International Commission on Shipping, ICON's report, headed Ships, Slaves and Competition, which basically suggested that for some seafarers, conditions in shipping, working conditions were akin to slavery. They were so bad. Seafarers were some of the most exploited workers and some of the most vulnerable. There was growing concern and understanding of the globalized nature of the sector, the various increasingly complex corporate arrangements I've referred to a few minutes ago were making it more and more difficult really to connect employers, workers, to sort out who was really responsible if there was a problem. From an ILO point of view, ILO conventions weren't widely ratified, weren't very evenly enforced, even though in maritime law there are some unique remedies, but generally the ILO standards were not there. At the same time, it was understood that the IMO regime, which we're maybe more familiar with dealing with ship safety, security, environmental protection, MARPOL, SOLAS, and so on. It was a relatively strong regime, well enforced, had certificates, ships were detained if they didn't comply, so that there tended to be an increasing move to get rid of substandard ships in terms of those issues, but yet substandard labor conditions were still in effect and difficult to tackle. So the idea really was to take some lessons from the IMO and put it into an ILO instrument to make it much more effective and put labor on the same plane in terms of enforcement as environmental concerns, safety concerns, and security. So what about the MLC? They worked for 5 years to adopt this convention. It's comprehensive. The idea was to bring together the existing body of standards, update them, modernize them. As you can imagine, some were very old, 1920s, 30s, and so on. So it brought together all the core standards in 37 conventions and related recommendations. This is sometimes called a one-stop shop convention. As I said, it's 100 pages long. Only 4 instruments were not included, 2 relating to a very technical area, biometrics and seafarer identity documents, 1 relating to pensions, and 1 relating to stokers, that is coal-fired ships, that is not really in use anymore. So this new convention, which is now called the 4th pillar, or it was intended to be the 4th pillar of the regulatory regime when it entered into force, was to stand next to MARPOL, SOLAS, and so on. I mentioned that they took some lessons from the IMO conventions, so it basically follows the same structure as the standards, what's called the STCW convention, standards for training of seafarers and watchkeepers. So it's organized into 3 different but related parts: articles, regulations, and a 2-part code. Part A, mandatory standards; Part B, non-mandatory guidelines, with an explanatory note trying to describe how all these parts fit together. This was an extremely new structure for an ILO convention. So very familiar in the IMO context, entirely new in the ILO context. I now am going to just walk us through a quick overview of the structure and the headings of the convention, and suggest to you that it took lessons. It's from the IMO. It's well organized. It's got a numerical system that once you understand it, you can work through it very quickly despite the length. But it's also comprehensive. So my purpose in putting some slides with the various headings and titles is just to give a sense of the coverage. So there's a preamble, has 16 articles. It's organized into 5 titles. The headings are set out on the slide. Title 1, minimum requirements for seafarers to work on ships. Title 2, conditions of employment. 3, accommodation and food, and so on. Title 4, social protection, health protection, medical care. And Title 5, a very strong title on enforcement and compliance. But it was a change from the IMO conventions in that it is what's called vertically integrated. So instead of being a series of linked books that one goes through from beginning to end, after the articles, the regulations and the code are integrated with, for example, my slide is showing you Regulation 1.2, medical certificate, is immediately followed by the code, Standard A 1.2, A indicating that it's a mandatory standard, and a guideline, B 1.2, guidance on medical certificates. So very quickly you can see the basic core requirements, some technical details found in the standard which can be changed fairly quickly under rapid updating, and additional guidance for implementation. All of these titles are to give effect to Article 5's provisions which tell us what seafarers' employment and social rights are. They are set out on the slide behind me. I think they're ones we would agree all workers should have. They have the right to a safe and secure workplace that complies with safety standards, right to fair terms of employment, right to decent working and living conditions on board ship, and a right to health protection, medical care, welfare measures, and other forms of social protection. It can be implemented in laws, regulations, or as very common in this sector, also in collective bargaining agreements. And many governments use something called marine notices or administrative notices also for implementation. I will just quickly now bring up slides showing the regulation headings. Each of these has standards and guidelines affiliated with them, but under the same heading. So just to give a sense of coverage. Under Title I, you'll see deals with minimum age, so seafarers must be at 16 or higher. Medical certificate, this deals with medical examinations, training and qualifications, and regulation of recruitment and placement services. Title II, conditions of employment, introduces very interesting new seafarer employment agreements, which are intended to bring ship owners and seafarers closer together in terms of a legal nexus. Requirements relating to payment of wages, hours of work or hours of rest, entitlement to leave, repatriation, and so on. Title III, accommodation, and also standards for food and catering. And some of these are very, very detailed. So for example, under accommodation, it sets out minimum standards for sleeping room size, for example, how many wash basins must be in sleeping rooms, and so on. So very technical. Title IV deals with the right to medical care. Title IV also has ship owners' liability to pay for medical care and wages when seafarers become sick while under contract. Health and safety protection, or occupational safety and health, access to seafarer shore-based welfare facilities, and importantly, and one where there's very large gap, Social Security for seafarers, largely because, as I mentioned at the beginning, seafarers are often resident in one country, and that's usually the country, if there is a Social Security system, that's normally the country that would be providing it, but often Social Security systems are contributory. So if you have a worker working out of the country for an employer that is not based in the country and may not be in fact based in the country where the ship is flagged, it's difficult to, it becomes complex to try to sort out how to get contributions to establish Social Security for seafarers later in their life, for example, old age coverage, maternity leave, other kinds of social benefits. Finally, Title V, I mentioned, very interesting, a very strong title on compliance and enforcement that sets out, and these are the three phases I mentioned at the beginning, flag state responsibilities, and the primary responsibility throughout this convention is flag state. Port state responsibilities, so this issue will be inspected now in port states, and labor supplying responsibilities where, for example, recruitment and placement services are operating. This title also has a list of matters for flag state inspection, same list is subject to inspection in port state, and I think perhaps the most innovative step from an ILO point of view is that it also establishes labor certification. So ships have to carry, ships above 500 gross tons going on international voyages have to carry on board a maritime labor certificate and several affiliated documents called Declarations of Maritime Labor Compliance, so DMLC, certifying that the ship has been inspected for, at this point, 14 areas. I'll show them to you in a minute. These certificates are subject to inspection in port state, and if there's any problems, the actual conditions themselves can be inspected. This is a big lesson learned from, as I said, the very strong regime under the IMO's certificates. So very interesting step on the part of the ILO. The 14 areas to be certified are, as set out on the slide, as you see, they're not the full list of areas in the regulation, but there are 14 of them. As you'll see, they're most of the core areas. In addition, in April of 2014, there were 2 amendments adopted to 2 areas where the code of the convention has been amended. And those amendments to deal with abandonment of seafarers and ship owners' liability for seafarer death and disability has introduced 2 more areas that will be on this list of areas to be certified: financial security for repatriation and financial security for ship owner liability. So again, a very interesting introduction of economic tools. That is, ship owners are going to have to, ships or ship owners will now have to have evidence that they have financial security in some form. Could be a insurance certificate or some other document covering their liability for repatriating the seafarers on board, and also for ship owners' liability, and to protect seafarers from abandonment, which is a serious problem when seafarers are abandoned in foreign ports and the ship owner may go bankrupt. All right, so what's happening with it? Is the convention in force? What's happened? It's all these new ideas. Well, it was intended to, it took 5 years to enter into force. It was adopted in 2006, and it took 5-6 years actually to enter into force. The idea was to avoid what's called a paper tiger, that is 100 pages of legal text, strong system, but nobody has ratified, or no country that has ships flagged under it has ratified. So very demanding formula. The convention was to come into force 12 months after the date on which there were registered ratifications by 30 members, and that's the ILO terminology for a country or a state, have ratified, representing at least 33% of the world gross tonnage of ships. So at least 1/3, the states representing 1/3 of the registered gross tonnage of the world shipping had to have ratified. So you had to have at least 1/3 of the states with an interest and a regulatory responsibility. After that formula was achieved, as is usual ILO practice, the convention enters into force for each country a year after it ratifies. The convention entered into force on 20th of August 2013 for the first 30 members. So as of 2012, 30 countries had ratified. The first 30 are set out on my slide in order of ratification, and you'll see, if you are familiar with this sector at all, that we're immediately the largest flag states in the world. That is, those with the most responsibility, most ships under their flag, ratified very early. Liberia, Marshall Islands, Bahamas, Panama is the largest flag state in the world, but the other 3 are very large and important flag states. Norway also. Bosnia Herzegovina is an important labor supplying state, a lot of seafarers. Number of countries in Europe ratified, including, I will note, Canada has ratified. Canada was in the first 30. A number of countries in the Caribbean and in Asia. Singapore led the way, Australia, so on, and the South Pacific nations. So Pacific Island nations, Russian Federation, Philippines, largest supplier of seafarers, Denmark, a very important ship owning and flag state, and so on. So quite a diverse range of countries, and not a fully global spread, but quite a strong global spread, so that at the time the convention entered into force, it was already ratified by countries that combined nearly 60% of the world fleet and included important port states such as Canada. As of now, February 2015, so 2 years later, 65 countries have ratified. That is, another 35 have ratified, representing more than 80% of the world gross tonnage, and many other countries have indicated they will be ratifying in the next year. That would be China, India, New Zealand, undoubtedly more countries in South and Latin America, and other countries in Asia. The list of countries that have now ratified, the remainder of the 65 are set out in this list, and they include, of course, also territories of those countries. So as you'll see, many of the European nations have now also, many more European nations have ratified. So I can see I'm coming close, more than close to my time to end. So just 2 more slides. So it's definitely on its way. What is the effect of it? Well, I think, why would we care? What difference is this going to make? Very nice these countries have ratified. Well, I think for those of us that are lawyers, perhaps working in this field or practicing, I think it's important to know that this year, so 1 year after entry into force, in around August 2014, one of the recognized ship classification society, DNV, reported that in the first year alone, it was aware of 160 ships detained in ports as a result of deficiencies identified under this convention. So this is a very expensive enforcement system, in the sense that if a ship is detained, it is extremely expensive for the ship owner and for cargo interests. So ship owners do not want to be detained. This causes very serious problems. In November 2014, the Paris MOU, one of the regional port-state control memorandums of understanding, reported that in the first year of their member enforcement of the MLC in their ports, they had 118 ship detentions in the same period. In addition, there were many more ship inspections, and deficiencies were identified in matters such as payment of wages, problems with seafarer employment agreements, failure to provide seafarers with adequate rest, thereby bringing about concerns for seafarer fatigue, and so on. So I think a convention that is, I think, going to achieve its goal of at least strengthening the compliance and enforcement regime. Importantly, the European Union adopted as regional law directives applying most of the provisions in the convention already to EU countries, even though they may not yet have ratified. So it's also being applied as a matter of European Union regional law. So this is also very important. There's a very high level of what I call industry interest. It's kind of become a niche market. So a lot of industry actors, port-state control MOUs, responsible recognized organizations, ROs, classification societies, providing guidance, training, numerous services such as ship certification and inspection relating to implementing the MLC. So quite a high level of industry buy, and I quite frankly can't recall of seeing too many apps before for an international convention, but there is an app for the MLC. So it's perhaps becoming very popular, and so this is a very unusual thing for international standards for workers. Importantly, a number of the provisions, for example, on medical examinations, minimum age, and training and so on, are already also reproduced in the most recent amendments to the IMO's STCW Convention, and that's already in force. The ITF, International Transportation Federation workers, which represents a lot of, a number of seafarers in the world, and ship owner-related employer organizations, have also implemented the MLC terms in their model or internationally agreed terms or international collective bargaining and national collective bargaining agreements. So already it's being replicated at the shipboard level in seafarers' employment agreements and in collective agreements, which are part of seafarer employment agreement. As I mentioned already, in April of this year, 2014, of the past year rather, April 2014, amendments to standards and guidelines were adopted to deal with financial security for abandonment and ship owner liability for death and personal injury for seafarers. These are expected to enter into force in January 2017. So to summarize, for the first time ever, there's an ILO Maritime Labor Convention that has a requirement for onboard documents for a maritime labor certificate and an DMLC certifying that seafarers' working and living conditions meet national requirements implementing the MLC, that it's combined with many other elements aimed at achieving universality and effective implementation at the state and shipboard level, including the role for seafarers in the event of non-compliance. There's still some difficult areas such as Social Security actors, but it provides a number of specific responses to what can be seen as a globalization problem. Some lessons could be taken to other sectors, but perhaps not all. Very, very important, and certainly the introduction of ideas of economic tools such as financial security for insurance for issues such as repatriation is also a very important step forward. So I apologize for running through this so quickly. I hope that you have found this presentation interesting. As I said, I'm more than happy to respond by email, or you can give me a call if you have any questions about the MLC or would like more information. There's a very comprehensive website on the ILO website for this convention, and a lot of guidance, and the convention itself can be downloaded with no charge. Thank you very much.